Number 10. The Twinkie Defense. Dan White's diminished capacity claim. On November 27, 1978, San Francisco was forever changed when former city supervisor Dan White entered City Hall through a basement window, carefully avoiding metal detectors, and systematically executed Mayor George Moscone and Supervisor Harvey Milk in cold blood. The premeditated nature of the crime seemed undeniable. White had resigned from his position as city supervisor just weeks earlier, citing financial difficulties and frustration with the political climate. But he quickly regretted his decision and asked Mayor Moscone to reappoint him to his seat. When Moscone, influenced by Harvey Milk and other progressive supervisors, decided to appoint someone else instead, White became consumed with rage and resentment. On that fateful morning, White loaded his .38 caliber revolver, brought extra ammunition, and made his way to City Hall with deadly intent. He climbed through the window to avoid the metal detectors at the main entrance, demonstrating clear premeditation and consciousness of guilt. White first confronted Mayor Moscone in his office, and after a brief conversation about the appointment decision, he shot Moscone twice in the body and then, as the mayor lay dying on the floor, fired 2 more shots into his head at point-blank range. White then calmly reloaded his weapon, walked across City Hall to Harvey Milk's office, and asked to speak with him privately. Once inside, White shot Milk 5 times, with the final shots fired execution style as Milk lay helpless on the floor. The brutality and calculated nature of these murders shocked the nation and seemed to guarantee that White would face first-degree murder charges with the possibility of the death penalty or life imprisonment without parole. However, White's defense team, led by attorney Douglas Schmidt, crafted a strategy that would become one of the most controversial and misunderstood legal defenses in American history, forever known as the Twinkie Defense, though this nickname grossly oversimplified the actual legal strategy employed. The defense never actually claimed that eating Twinkies made White commit murder, but rather argued for a charge of voluntary manslaughter instead of first-degree murder by demonstrating that White suffered from severe depression that diminished his capacity to premeditate or deliberate the killings. Under California law at the time, diminished capacity was an acceptable defense that could reduce a murder charge if the defendant's mental state prevented them from forming the specific intent required for first-degree murder. The defense presented extensive testimony from psychiatrist Martin Blinder, who explained that White had been suffering from severe clinical depression in the weeks leading up to the murders, and that this depression was evidenced by various behavioral changes, including his resignation from the Board of Supervisors, his withdrawal from friends and family, and notably, his abandonment of his typically health-conscious diet in favor of junk food, including Twinkies, Coca-Cola, and other sugary products. Dr. Blinder testified that White's consumption of junk food was not the cause of his violent behavior, but rather a symptom of his underlying depression, as he had previously been an athletic, health-focused former police officer and firefighter who suddenly stopped exercising and began eating poorly. The prosecution, led by District Attorney Joseph Freitas and Assistant DA Thomas Norman, failed to effectively counter this diminished capacity argument, perhaps because they underestimated the defense strategy or overestimated the strength of their premeditation evidence. The trial, which began in May 1979, featured emotional testimony from witnesses who described the murders and the political tensions at City Hall, but the defense successfully kept the focus on White's mental state rather than his actions or motivations. Defense attorneys portrayed White as a hardworking family man who had dedicated his life to public service, first as a police officer, then as a firefighter, then as a city supervisor representing a conservative, working-class district in San Francisco. They emphasized his military service, his clean record, and his reputation as someone who cared deeply about his community, painting a picture of a man who had simply broken under tremendous psychological pressure. The prosecution attempted to demonstrate that White's actions were clearly premeditated by pointing to the fact that he brought extra ammunition, avoided the metal detectors, and killed both men execution style, but the jury ultimately found the diminished capacity argument more compelling. On May 21, 1979, after deliberating for just over a day, the jury returned a verdict that stunned San Francisco and the nation: guilty of voluntary manslaughter, not murder. The verdict meant that instead of facing life in prison or the death penalty, Dan White would serve a maximum of 7 years and 8 months in prison. Judge Walter Calcagno sentenced White to the maximum term allowed under the voluntary manslaughter conviction, but with time served and good behavior, White would be eligible for parole in just 5 years. The verdict sparked immediate outrage, particularly in San Francisco's gay community, which viewed Harvey Milk as a pioneering civil rights leader and saw the lenient verdict as a miscarriage of justice influenced by homophobia and political bias. On the night of the verdict, thousands of protesters descended on City Hall in what became known as the White Night Riots, resulting in over 140 injuries, 61 police officers hurt, and millions of dollars in property damage as demonstrators smashed windows, set police cars on fire, and clashed with officers. The district attorney's office faced severe criticism for their handling of the case, with many legal experts arguing that they should have fought harder against the diminished capacity defense and presented stronger psychiatric evidence to counter the defense's claims. The Twinkie Defense, as it became known in popular culture, led directly to significant changes in California law. In 1981, California voters approved a ballot initiative that abolished the diminished capacity defense, preventing future defendants from using mental impairment to reduce murder charges to manslaughter in this manner. The case also influenced legal reforms across the country, with many states either eliminating or significantly restricting diminished capacity defenses. Dan White served just 5 years and 1 month at Soledad Prison before being paroled in January 1984, and he was released to Los Angeles County under strict parole conditions that prohibited him from returning to San Francisco. Despite initial plans to start a new life in Ireland, White eventually returned to San Francisco in 1985 after his parole ended, but he struggled with depression, guilt, and the weight of public hatred. On October 21, 1985, less than 2 years after his release from prison, Dan White died by suicide in his garage, connecting a hose from his car's exhaust pipe into the vehicle's interior, a tragic end that many saw as delayed justice but others viewed as evidence of the genuine mental illness that had plagued him throughout the ordeal. The legacy of the Twinkie Defense remains controversial to this day, serving as a cautionary tale about the potential for psychiatric testimony to be misused in criminal trials, the importance of effective prosecution in high-profile cases, and the dangers of allowing sympathy for a defendant's mental state to overshadow the severity of their criminal actions and the rights of their victims. Number 9. The sleepwalking defense. Kenneth Parks and the unconscious murder in the early morning hours of May 23, 1987. Kenneth Parks, a 23-year-old Toronto man with no history of violence and no apparent motive, drove 14 miles from his home in Pickering, Ontario, to the Scarborough home of his in-laws, Barbara and Dennis Woods, whom he had always maintained a warm and affectionate relationship with, and proceeded to brutally attack them while they slept. Parks used a tire iron from his car to bludgeon his father-in-law and a knife from the Woods' kitchen to stab his mother-in-law repeatedly, killing Barbara Woods and severely injuring Dennis Woods, who survived the attack. After the violent assault, Parks drove directly to a police station, his hands severely cut and injured from the attack, and told officers in a confused and disoriented state that he believed he had killed someone. The physical evidence was overwhelming and undeniable. Parks' hands bore deep lacerations consistent with gripping a knife during a violent struggle, with several tendons completely severed, injuries so severe that they required immediate surgical intervention and would result in permanent partial disability in both hands. Blood evidence, witness statements, and Parks' own admission that he had been at the scene created what appeared to be an open-and-shut case of first-degree murder. However, Parks and his defense team, led by attorney Marlis Edward, put forward one of the most unusual and scientifically complex defenses in Canadian legal history. Kenneth Parks was completely asleep during the entire incident and therefore could not be held criminally responsible for his actions because he lacked the conscious intent required for murder. The defense argued that Parks suffered from a parasomnia disorder, specifically a condition involving complex sleepwalking behaviors, and that on the night of May 23, he had been in a state of automatism, a legal term referring to unconscious, involuntary action where the mind is disassociated from the body. To understand how this defense could possibly succeed, one must examine the extensive background evidence presented at trial regarding Parks' sleep patterns, his mental state in the weeks leading up to the incident, and the scientific testimony about sleepwalking and automatism. Kenneth Parks had been experiencing severe stress in the months before the attack due to significant financial problems, including gambling debts and the recent loss of his job, problems that he had confided to his in-laws, who had been supportive and understanding. Parks had a documented family history of sleepwalking and other sleep disorders, with his grandfather, father, and siblings all having experienced episodes of sleepwalking, sleep-talking, and other parasomnias throughout their lives. In the weeks before the killing, Parks' wife had noticed that he was sleeping poorly, often tossing and turning violently in his sleep, and on several occasions she had found him wandering around their home in the middle of the night with no memory of having gotten out of bed. On the night of May 22nd going into the early morning of May 23rd, Parks went to bed around 1:30 in the morning after watching television, and the next thing he could remember with any clarity was standing in the police station with bloody hands, wondering what had happened and how he had gotten there. The defense team assembled an impressive array of sleep specialists, neurologists, and psychiatrists who testified about the science of sleepwalking and the possibility of complex motor behaviors occurring during deep sleep stages. Dr. Roger Broughton, a leading sleep researcher from the University of Ottawa, testified that Parks underwent extensive polysomnography testing at a sleep laboratory, where his brain waves, muscle activity, and sleep patterns were monitored throughout multiple nights. These tests revealed that Parks experienced unusually deep slow-wave sleep and had several episodes where he exhibited motor activity consistent with sleepwalking, including sitting up, moving his limbs, and even getting out of bed without any conscious awareness or memory of these actions. Dr. Broughton explained to the jury that during certain stages of deep sleep, the brain can enter states where motor control areas become active while consciousness and memory formation areas remain dormant, allowing for complex physical actions to occur without any conscious intent or subsequent memory. The prosecution, led by Crown Attorney Patrick Galligan, vigorously challenged this defense, arguing that the complexity of Parks' actions, including driving 14 miles through city streets, navigating to a specific address, obtaining weapons, and executing a violent attack, demonstrated far too much purposeful behavior to be the result of unconscious sleepwalking. They presented their own psychiatric experts who testified that true sleepwalking episodes typically involve simple, repetitive behaviors in familiar environments and that violent, goal-directed actions like those Parks committed would be virtually impossible for someone in a genuine sleep state. The Crown also emphasized that Parks had motive to harm his in-laws or stage an incident that would allow him to escape his financial and personal problems, suggesting that the sleepwalking defense was a convenient fabrication. However, the defense successfully countered these arguments by pointing out that Parks had an excellent relationship with his in-laws, who he affectionately called Mom and Dad, that Barbara Woods had recently given him money to help with his gambling debts, and that Dennis Woods had been helping him find new employment. The defense asked why, if Parks was conscious and planning a murder, he would drive directly to a police station afterward with bloody hands and openly admit that he thought he had killed someone, behaviors completely inconsistent with conscious guilt or an attempt to evade responsibility. Expert witnesses testified that while violent behavior during sleepwalking is extremely rare, it is not impossible, particularly when the sleepwalker is in an abnormally deep sleep state and experiences a sudden arousal or confusional episode. Dr. Broughton explained that Parks' severe sleep deprivation due to stress, combined with his genetic predisposition to parasomnias, created conditions where a violent sleepwalking episode, though highly unusual, was medically possible. The defense also presented evidence that Parks showed no attempt to conceal his actions, did not take any steps to avoid detection, and immediately turned himself into police, all behaviors inconsistent with conscious criminal intent. Perhaps most compellingly, the defense demonstrated that Parks had suffered severe injuries to his hands during the attack, but reported feeling no pain during the incident or immediately afterward, a phenomenon consistent with the decreased pain perception that occurs during deep sleep stages. The trial, which took place in 1988 at the Ontario Supreme Court, resulted in an acquittal, with Justice David Watt instructing the jury that if they had reasonable doubt about whether Parks was conscious during the attack, they must find him not guilty. The jury deliberated and returned a verdict of not guilty, accepting the sleepwalking defense and finding that Parks had acted in a state of non-insane automatism, meaning his unconscious state was caused by an external factor, his sleep disorder, rather than a mental disease requiring treatment. The Crown appealed this verdict to the Ontario Court of Appeal, arguing that the trial judge had erred in his instructions to the jury and that the evidence did not support a finding of non-insane automatism, but the Court of Appeal upheld the acquittal in 1990. The Crown then appealed to the Supreme Court of Canada, the highest court in the nation, which heard arguments about whether sleepwalking could constitute a valid automatism defense and whether Parks' condition should have been classified as insane automatism, which would have resulted in psychiatric detention rather than acquittal. In a landmark 1992 decision, the Supreme Court of Canada upheld Parks' acquittal in a 6-3 ruling, with the majority finding that the trial judge had properly instructed the jury and that the evidence supported the conclusion that Parks had been in a genuine state of unconsciousness during the attack. The court established important legal precedents about automatism defenses, holding that sleepwalking could constitute non-insane automatism if it was caused by a normal sleep disorder rather than a mental illness, and that defendants bearing the burden of proving automatism must present clear medical and scientific evidence. Kenneth Parks walked free after the Supreme Court decision, though he carried the psychological burden of having killed his beloved mother-in-law and seriously injured his father-in-law, even if he had no conscious memory or intent regarding these actions. The case has been cited in numerous subsequent trials involving sleepwalking defenses, though courts have generally been more skeptical of such claims in the wake of Parks, requiring extensive medical documentation and sleep study evidence before accepting automatism arguments. The Parks case remains one of the most scientifically fascinating criminal cases in legal history, raising profound questions about consciousness, criminal responsibility, free will, and the nature of intent, while also highlighting the importance of rigorous scientific evidence in courtrooms when dealing with complex neurological and psychiatric conditions. Number 8. The Urban Survival Syndrome defense Damian Osby and the argument of environmental conditioning. In April 1994, Damian Osby, a 17-year-old African-American teenager from Fort Worth, Texas, shot and killed a man during what prosecutors characterized as a gang-related confrontation, a killing that seemed destined to result in a murder conviction and lengthy prison sentence for the young defendant. However, Osby's defense attorney, David Byers, introduced a novel and highly controversial defense strategy that would spark intense debate about race, poverty, criminal responsibility, and the effects of environmental trauma on youth in America's most dangerous neighborhoods. Byers argued that Osby suffered from what he termed urban survival syndrome, a condition allegedly caused by growing up in an environment of constant violence, poverty, and danger that fundamentally altered the young man's perception of threats and his fight-or-flight responses. The defense theory posited that children raised in war-zone-like urban environments, where gunfire, gang violence, drug dealing, and death are daily realities, develop a heightened state of vigilance and altered threat assessment that can cause them to perceive danger and respond with violence in situations where someone from a safer environment would not feel threatened. Osby had grown up in the Stop 6 neighborhood of Fort Worth, an area plagued by gang violence, drug trafficking, and one of the highest murder rates in Texas during the early 1990s. Defense witnesses testified that by the age of 17, Osby had personally witnessed multiple shootings, had lost friends and family members to gang violence, and lived in a community where going outside carried genuine risks of being shot, robbed, or assaulted. Dr. William Jenkins, a psychologist who evaluated Osby, testified that the teenager exhibited symptoms consistent with post-traumatic stress disorder typically seen in combat veterans, including hypervigilance, exaggerated startle responses, and persistent fear for his personal safety. Jenkins explained that Osby's brain had been conditioned by years of exposure to violence to perceive threats differently than someone raised in a safe suburban environment, and that this conditioning was not a mental illness but rather a rational adaptation to an irrational and dangerous environment. The defense presented evidence that on the day of the shooting, Osby encountered the victim in circumstances that he perceived as immediately life-threatening based on his experiences and knowledge of gang dynamics in his neighborhood, and that his decision to shoot was not the result of criminal intent but rather an almost involuntary survival response triggered by his environmental conditioning. The prosecution vigorously opposed this defense, arguing that allowing defendants to escape responsibility for violent crimes by blaming their environment would essentially immunize gang members and criminals from accountability, create a dangerous precedent that would make it nearly impossible to prosecute violent crimes in high-crime neighborhoods, and perpetuate racist stereotypes about urban youth. District Attorney Tim Curry argued that Osby was trying to excuse cold-blooded murder by claiming that growing up poor and black in a violent neighborhood gave him a license to kill, a characterization that the defense strongly disputed. The prosecution presented evidence that Osby was a known gang member, that the shooting was part of ongoing gang hostilities, and that he made conscious choices to participate in gang activities and to carry a firearm, choices that demonstrated criminal intent regardless of his environmental background. The trial became a lightning rod for debates about crime, race, and justice in America, with civil rights advocates arguing that the urban survival syndrome defense highlighted the very real psychological impacts of institutional racism, economic inequality, and concentrated poverty on young people in marginalized communities, while conservative critics argued that the defense was a dangerous attempt to excuse criminal behavior and deny personal responsibility. Media coverage of the case was intense and often sensationalized, with some outlets portraying the defense as a radical attack on traditional notions of criminal accountability, while others saw it as a long-overdue recognition of how environmental trauma affects human psychology and behavior. The jury in Osby's case deliberated for several days, ultimately finding him guilty of murder, but the judge, recognizing the complexities raised by the defense arguments, sentenced Osby to a relatively lenient term compared to what he might have received without the urban survival syndrome evidence. While the defense did not result in a complete acquittal, legal analysts considered it a partial success because it appeared to have influenced the sentencing decision and brought attention to the environmental factors that contribute to youth violence. The Osby case inspired similar defense strategies in subsequent trials, with defense attorneys in various jurisdictions attempting to introduce evidence of environmental trauma, neighborhood violence exposure, and poverty-related stress as mitigating factors in violent crime cases. In 1995, a similar defense was attempted in the case of Felicia Morgan, a woman charged with murder in Washington, D.C., where her attorney argued that she suffered from urban survival syndrome due to her upbringing in a violent housing project. Though this defense was ultimately rejected by the court, legal scholars and psychologists have debated the validity of urban survival syndrome as a genuine psychological condition, with some arguing that it is simply PTSD given a new name while others contend that it represents a distinct form of environmental conditioning not adequately captured by existing diagnostic categories. Critics of the defense argue that it risks creating a two-tiered system of justice where individuals from disadvantaged backgrounds are held to different standards of criminal responsibility than those from privileged environments, potentially reinforcing rather than challenging societal inequalities. Supporters counter that the criminal justice system already operates with implicit biases that favor wealthy defendants who can afford extensive psychiatric evaluations, expert witnesses, and creative legal strategies, and that recognizing the psychological impacts of growing up in violent, impoverished communities is simply acknowledging an empirical reality rather than excusing criminal behavior. The debate also touches on fundamental questions about free will, determinism, and moral responsibility, asking whether someone who has been shaped by extreme environmental circumstances can truly be said to have freely chosen their actions or whether their choices have been so constrained by their experiences that they deserve different consideration under the law. The urban survival syndrome defense has largely fallen out of favor in American courtrooms since the 1990s, with judges increasingly reluctant to allow expert testimony on the subject and prosecutors successfully arguing that such defenses are more prejudicial than probative. However, the underlying issues raised by the Osby case continue to resonate in discussions about criminal justice reform, juvenile sentencing, and the treatment of trauma-affected individuals in the legal system. Modern approaches to these questions tend to focus on presenting evidence of trauma and environmental stress as mitigating factors during sentencing rather than as complete defenses to criminal liability, a compromise that acknowledges the real impacts of adverse childhood experiences while maintaining basic standards of criminal accountability. The case also contributed to broader conversations about the school-to-prison pipeline, the criminalization of poverty, and the need for trauma-informed approaches to juvenile justice, influencing policy debates even as the specific legal defense strategy proved largely unsuccessful in subsequent cases. Number 7. The identical twin defense. The unidentifiable DNA match. In January 2009, a massive jewelry heist occurred at the Kaufhaus de Westens department store in Berlin, Germany, where thieves made off with luxury watches, diamonds, and other valuable items worth approximately 6.8 million euros in one of the most audacious robberies in German history. The sophisticated crime was executed with precision timing, detailed knowledge of the store's security systems, and careful planning that suggested the involvement of professional criminals with extensive experience in high-value thefts. Police investigations quickly identified DNA evidence left at the crime scene on a latex glove that had been discarded by one of the thieves during their escape, and this DNA was run through Germany's National Criminal Database, producing a match to Hassan O., a known criminal with a history of theft and burglary who had been previously convicted and whose genetic profile was on file with authorities. However, Hassan O. had an identical twin brother, Abbas O., and both men had prior criminal records, creating an extraordinarily unusual situation where law enforcement had solid DNA evidence that one of the two brothers had participated in the robbery but lacked any method to definitively determine which one had actually committed the crime. Identical twins, also known as monozygotic twins, develop from a single fertilized egg that splits during early embryonic development, resulting in two individuals who share virtually identical DNA sequences, making standard forensic DNA testing unable to distinguish between them. The DNA evidence that would normally be considered the gold standard of forensic science, capable of identifying one individual among billions with near certainty, was rendered useless by the biological reality that Hassan and Abbas were genetic duplicates. Prosecutors faced a seemingly impossible dilemma. They had ironclad evidence that one of the two brothers had committed the robbery, but German law, like the legal systems of most democratic nations, requires proof beyond a reasonable doubt that a specific individual committed a crime, and the DNA evidence alone could not meet this burden when there were two equally possible suspects. Police conducted extensive investigations attempting to find other evidence that would differentiate between the twins and identify which one had participated in the heist. They examined phone records, financial transactions, surveillance footage from areas near the department store, witness statements, and alibis provided by both brothers, but neither twin could be definitively placed at the scene or ruled out as a suspect. Both Hassan and Abbas denied any involvement in the robbery, each suggesting that if DNA evidence existed, it must implicate his brother rather than himself, a perfectly symmetrical defense that prosecutors could not overcome. The case highlighted significant limitations in forensic DNA technology when applied to identical twins and raised fascinating legal and ethical questions about criminal responsibility, the burden of proof, and the nature of individual identity. German prosecutors consulted with forensic experts and genetic scientists to determine whether any emerging technologies might be able to distinguish between the twins' DNA, and they learned that while cutting-edge epigenetic testing might theoretically detect minor differences caused by environmental factors and lifestyle choices that affect gene expression rather than the underlying DNA sequence itself, such testing was not yet reliable enough for courtroom use and might not detect sufficient differences to definitively identify one twin versus the other. The prosecution considered whether they could charge both brothers jointly with the robbery, arguing that even if they could not prove which one had physically participated in the crime, they could demonstrate that both had knowledge of and involvement in the criminal enterprise. But this strategy faced significant legal obstacles because there was no evidence beyond the DNA that either brother had been involved, and charging both men for the same crime based solely on shared genetic material would likely violate fundamental principles of individual criminal responsibility. Defense attorneys for both brothers argued that the case demonstrated the dangers of over-reliance on forensic DNA evidence and the importance of maintaining high standards of proof in criminal prosecutions, contending that if the state could not prove which specific individual committed a crime, both suspects must go free rather than punishing potentially innocent people. The philosophical implications of the case were profound, raising questions about the nature of identity and whether identical twins should be considered distinct legal persons if they are indistinguishable by the most advanced scientific methods available to the justice system. In May 2009, after months of investigation and legal deliberation, German prosecutors made the remarkable decision to drop all charges against both Hassan and Abbas, announcing that while they remained convinced that one of the brothers had participated in the robbery, they could not meet the legal standard of proving beyond a reasonable doubt which one was guilty, and that prosecuting both men without such proof would be unjust and unconstitutional. The decision sparked significant public debate, with some commentators arguing that the twins had exploited a biological loophole to literally get away with robbery, while others praised prosecutors for upholding the integrity of the criminal justice system by refusing to secure convictions without adequate proof. The case prompted discussions among forensic scientists and legal experts about whether new technologies might eventually solve the identical twin problem, and researchers have since made progress in developing advanced DNA analysis techniques that examine epigenetic markers, differences in DNA methylation patterns, and rare mutations that occur after the initial splitting of the embryo that might theoretically allow forensic scientists to distinguish between identical twins in some cases. However, as of today, these technologies remain expensive, time-consuming, and not yet reliable enough for routine use in criminal investigations, meaning that cases involving identical twins and DNA evidence continue to pose significant challenges for law enforcement and prosecutors. The identical twin defense has been successfully employed in various criminal cases around the world, though instances where it results in complete acquittal or drop charges are relatively rare because most cases involve additional evidence beyond DNA that can identify the specific perpetrator. In a 2014 case in Malaysia, A man accused of drug trafficking successfully argued that DNA evidence found on packages of methamphetamine could have come from either him or his identical twin brother, creating reasonable doubt that resulted in his acquittal when prosecutors could not present other evidence definitively linking him to the drugs. Similarly, in a 2017 murder case in the United States, defense attorneys for a suspect attempted to argue that DNA found under the victim's fingernails could have come from their client's identical twin, though in that case additional evidence including witness testimony and the twins' airtight alibi allowed prosecutors to secure a conviction. The phenomenon of identical twins in criminal cases also raises interesting questions about criminal conspiracy and joint liability, as some legal theorists have argued that if identical twins are truly indistinguishable by forensic science, perhaps the law should treat them as a single entity for purposes of criminal responsibility when DNA evidence is the only evidence available, a radical proposal that has been almost universally rejected by courts and legal scholars as incompatible with basic principles of individual rights and due process. The Berlin jewelry heist case remains one of the most famous examples of the identical twin defense working exactly as legal principles require, with the prosecution unable to meet its burden of proof and both suspects going free despite strong evidence that one of them committed the crime. The case serves as an important reminder that criminal justice systems in democratic societies are designed to err on the side of protecting the innocent, even when that means that some guilty individuals may escape punishment, and that advances in forensic science, while tremendously valuable, cannot solve every evidentiary problem or overcome fundamental limitations imposed by biology, law, and ethics. Number 6. The affluenza defense. Ethan Couch and the consequences of wealth. On June 15, 2013, 16-year-old Ethan Couch stole beer from a Walmart in Burleson, Texas, got behind the wheel of his family's Ford F-350 pickup truck while severely intoxicated with a blood alcohol content 3 times the legal limit for adults and with Valium in his system, and proceeded to drive recklessly at 70 miles per hour in a 40-mile-per-hour zone before losing control of the vehicle and crashing into a group of people who had stopped to help a stranded motorist on the side of the road. The crash killed 4 people instantly. Brianna Mitchell, a 24-year-old woman whose car had broken down, Holly Boyles and Shelby Boyles, a mother and daughter who had come out of their nearby home to offer assistance, and Brian Jennings, a youth pastor who had also stopped to help. The violent collision also seriously injured 9 other people, including 2 of Couch's passengers who were thrown from the truck bed where they had been riding, with one suffering traumatic brain injuries so severe that he lost the ability to move or speak and would require round-the-clock care for the rest of his life. The evidence against Couch was overwhelming and indisputable. Investigators found that he had been driving with a blood alcohol content of 0.24%. Surveillance footage from Walmart showed him stealing the beer. Witnesses described his reckless driving in the minutes before the crash, and the physical evidence at the scene demonstrated that he was traveling at dangerously high speeds. Couch initially fled the scene after the crash but was quickly apprehended by police. Given the severity of the crime, the multiple deaths, the serious injuries, and Couch's apparent complete disregard for the safety of others, prosecutors sought to have him tried as an adult and sentenced to 20 years in prison, the maximum allowed under Texas law for cases involving multiple deaths caused by intoxication manslaughter. However, at Couch's sentencing hearing in juvenile court, his defense team introduced testimony from psychologist Dr. Gary Miller, who argued that Couch suffered from a condition that the media quickly dubbed affluenza, a portmanteau of affluence and influenza, suggesting that wealthy children can become psychologically impaired by their privileged upbringings. Dr. Miller testified that Ethan Couch had been raised by extremely wealthy parents who gave him virtually everything he wanted, never established meaningful boundaries or consequences for his behavior, never taught him that actions have consequences, and essentially failed to prepare him for the real world by shielding him from any responsibility or accountability throughout his childhood. Miller explained that the Couch family's wealth, estimated at around $15 million from their successful sheet metal business, had allowed Ethan's parents to indulge his every whim, buy their way out of problems, and prevent him from ever experiencing normal consequences for misbehavior, creating a teenager who genuinely did not understand that his actions could hurt others, or that he could be held responsible for his choices. The psychologist described how Couch's parents had provided him with money, vehicles, and freedom without supervision, that his father had allowed him to drive at age 13 without a license, that he had been given access to alcohol and had been found by police passed out drunk in a vehicle with a naked 14-year-old girl when he was just 15 years old, an incident that resulted in no meaningful consequences because his parents had intervened. Dr. Miller testified that this pattern of enabling had produced a young person who was emotionally and morally underdeveloped, lacking the normal capacity to understand right from wrong or to appreciate the impact of his actions on others, not because of any inherent mental illness but because his environment of extreme privilege had prevented him from developing these capacities. The defense argued that Couch needed treatment and rehabilitation in a therapeutic environment rather than punishment in the juvenile detention system, and they proposed that he be sent to a private, upscale rehabilitation facility in California at his family's expense rather than being incarcerated. The prosecution and the victims' families were outraged by this defense strategy, arguing that it was obscene to suggest that being wealthy excused someone from criminal responsibility for killing 4 people and injuring 9 others, and that allowing Couch to receive treatment at a luxury facility instead of serving time in detention would send a terrible message that rich people can literally get away with murder. Victim advocates pointed out that poor and middle-class teenagers who committed similar crimes would never receive such lenient treatment, and that the affluenza defense exemplified the two-tiered justice system that favors the wealthy and punishes the disadvantaged. Prosecutors presented evidence of Couch's prior bad behavior, including the incident with the drunk driving and the underage girl, and argued that he clearly knew right from wrong because he had taken steps to hide his beer theft and had fled the scene after the crash, demonstrating consciousness of guilt. Despite these arguments, Judge Jean Boyd, who was presiding over the case in juvenile court, accepted key elements of the affluenza argument and sentenced Ethan Couch to 10 years probation with treatment at a long-term residential therapy facility rather than detention in the juvenile system. The judge ordered that Couch would be sent to a treatment center and would not be released until therapists determined he was sufficiently rehabilitated, but she declined to send him to a lockdown juvenile detention facility. The sentence sparked immediate national outrage and became a symbol of inequality in the American justice system, with countless news stories, opinion pieces, and television segments discussing the case and the concept of affluenza. Victims' families gave emotional statements to the media, with Eric Boyles, who lost his wife and daughter in the crash, saying that he had never seen such injustice in his life and that the message being sent was that if you have money, you can get away with anything. The backlash against Judge Boyd was severe, with many calling for her removal from the bench, though she defended her decision by arguing that the juvenile justice system is meant to rehabilitate rather than punish, and that sending Couch to detention would not help him or protect society as effectively as intensive therapy. The story took another dramatic turn in December 2015, when a video surfaced on social media appearing to show Ethan Couch at a party where people were playing beer pong and drinking alcohol, a clear violation of his probation terms which explicitly prohibited him from consuming alcohol or being in environments where alcohol was present. When Couch's probation officer attempted to contact him about the video, Couch and his mother, Tanya Couch, fled the country and disappeared, prompting an international manhunt. Law enforcement officials traced the pair to Puerto Vallarta, Mexico, where they were living under assumed identities and had apparently planned to evade U.S. authorities indefinitely. Mexican immigration officials and U.S. Marshals located and apprehended them in December 2015, and they were deported back to the United States to face charges related to their flight from justice. Ethan Couch was taken into custody and, because he had now turned 18 and violated his probation, prosecutors were able to transfer his case to adult court. Tanya Couch was charged with hindering apprehension of a felon and money laundering for her role in helping her son flee the country. In April 2016, a judge sentenced Ethan Couch to nearly 2 years in county jail for violating his probation, with the sentence structured so that he would serve 180 days for each of the 4 victims he had killed, to be served consecutively. This was still far less than the 20 years he might have received if he had been sentenced as an adult originally, but it represented a partial correction to what many viewed as the initial miscarriage of justice. Couch was released from jail in April 2018 after serving his sentence, and he remains on probation until 2024 with strict conditions including regular drug testing, GPS monitoring, and prohibitions on drinking alcohol or using drugs. His mother, Tanya Couch, pleaded guilty to hindering apprehension and was sentenced to 120 days in jail and 8 years of probation. The affluenza case had lasting impacts on public discourse about wealth, privilege, and criminal justice, contributing to broader conversations about inequality in the legal system and the different treatment afforded to wealthy defendants versus poor defendants. Studies and statistical analyses have consistently shown that defendants with resources to hire expensive attorneys, retain expert witnesses, and present sophisticated mitigation evidence receive more lenient sentences on average than similarly situated defendants who rely on public defenders and cannot afford such resources, and the Couch case brought this reality into sharp focus for millions of Americans. The concept of affluenza itself, while ridiculed by many, does reflect genuine psychological research showing that extreme wealth can have negative effects on child development, particularly when combined with parental neglect, lack of boundaries, and absence of consequences for misbehavior, though most psychologists reject the idea that this should constitute a legal defense to serious crimes. The case also highlighted the problematic aspects of juvenile justice systems that allow for vastly different outcomes based on judicial discretion, family resources, and the ability to afford private treatment options, leading some advocates to call for reforms that would create more standardized sentencing guidelines for serious juvenile offenses. Judge Jean Boyd retired from the bench in 2014, before the completion of Ethan Couch's probation period, and she never publicly expressed regret for her sentencing decision, though many legal experts and victims' rights advocates continue to cite the case as an example of judicial failure and the dangers of allowing sympathy for a defendant's circumstances to overshadow the seriousness of their crimes and the suffering of their victims. Number 5. The irresistible impulse defense. Lorena Bobbitt's act of desperation. On the night of June 23, 1993, Lorena Bobbitt, a 24-year-old Ecuadorian immigrant living in Manassas, Virginia, committed an act that would become one of the most sensationalized criminal cases in American history and spark intense debates about domestic violence, temporary insanity, and the treatment of abuse victims in the criminal justice system. After years of alleged physical, sexual, and emotional abuse at the hands of her husband, John Wayne Bobbitt, and following what she claimed was a violent rape that night, Lorena took a 12-inch carving knife from the couple's kitchen and severed her husband's penis while he slept, then fled the apartment carrying the severed member, which she threw out of her car window into a field as she drove away in a state of panic and confusion. Lorena drove to the home of her friend and employer, where she called 911 to report what she had done, while John Wayne Bobbitt awoke to discover his injury and also called for emergency assistance. Police and rescue workers were able to locate the severed penis in the field where Lorena had discarded it, thanks to her description of the location, and it was rushed to the hospital where a team of surgeons performed a successful 9.5-hour microsurgical reattachment procedure. Lorena Bobbitt was arrested and charged with malicious wounding, a felony under Virginia law that carried a potential sentence of up to 20 years in prison, and the case immediately became a media sensation, with tabloid newspapers, television news programs, and late-night comedy shows fixating on the salacious details of the case and the unusual nature of the crime. However, beneath the sensationalism lay a serious case involving domestic violence, sexual assault, and questions about what constitutes self-defense or temporary insanity in the context of ongoing abuse. Lorena's defense team, led by attorneys James Lowe and Lisa Kemmler, built their strategy around demonstrating that she had been subjected to years of severe domestic abuse by John Wayne Bobbitt, and that on the night of the incident, she had experienced an irresistible impulse brought on by temporary insanity, causing her to commit an act she would never have contemplated in a normal mental state. The defense presented extensive testimony from Lorena herself, who described in detail the pattern of abuse she had endured during her 4-year marriage to John. She testified that he had repeatedly raped her, beaten her, forced her to have abortions, humiliated her, controlled her finances, isolated her from friends and family, and subjected her to constant verbal abuse and threats. Lorena recounted specific incidents of violence, including times when John had punched her, thrown her against walls, forced himself on her sexually despite her protests, and threatened to have her deported if she tried to leave him or report his abuse to authorities. She testified that on the night of June 23, John had come home late after drinking with friends, had forced her to have sex against her will despite her protests and resistance, and had then fallen asleep while she lay awake crying and emotionally devastated. Lorena described entering a dissociative mental state, where she got out of bed, went to the kitchen for a glass of water, saw the knife on the counter, and suddenly was overcome by a flood of memories of all the abuse she had suffered, all the times he had hurt her, raped her, and degraded her, and in that moment she experienced what psychologists would later describe as an acute stress reaction or temporary psychotic break. She testified that she took the knife, returned to the bedroom, and cut off his penis in what felt like an almost automatic, involuntary action, as if she was watching herself from outside her own body, and that immediately afterward she fled in a panic, not knowing what she had done or why, only knowing she had to get away. The defense brought in multiple expert witnesses, including psychiatrists and psychologists, who evaluated Lorena and testified about the psychological effects of prolonged domestic abuse, a condition now often referred to as battered woman syndrome or intimate partner violence trauma syndrome. Dr. Susan Feaster, a clinical psychologist, testified that Lorena exhibited all the classic symptoms of someone who had been subjected to chronic domestic violence, including learned helplessness, traumatic bonding to her abuser, depression, anxiety, and post-traumatic stress disorder. Feaster explained that victims of long-term domestic abuse often develop a state of hypervigilance and heightened stress that can, in extreme circumstances, lead to dissociative episodes or temporary breaks from reality, particularly when combined with acute stressors like sexual assault. The expert testified that Lorena's action of severing her husband's penis was not a premeditated act of revenge, but rather an impulsive reaction triggered by an irresistible impulse during a temporary psychotic state brought on by the cumulative trauma of years of abuse combined with the immediate trauma of being raped that night. The prosecution, led by Commonwealth's attorney Paul Ebert, challenged this defense vigorously, arguing that Lorena's action was deliberate, vengeful, and premeditated, not the result of temporary insanity. They pointed out that she had gotten out of bed, walked to the kitchen, selected a knife, returned to the bedroom, and performed a precise cutting action, all of which suggested conscious, purposeful behavior rather than unconscious impulse. The prosecution called John Wayne Bobbitt to testify, and he denied all allegations of abuse, claiming that Lorena was lying to avoid prison and that their relationship, while sometimes contentious, had never involved the kind of systematic violence and sexual assault she described. However, John's credibility was significantly undermined during cross-examination when defense attorneys presented evidence of his history of violence, including a previous assault charge, and when they highlighted inconsistencies in his testimony and his admission that he had been drinking heavily on the night in question and could not remember many details. The prosecution also called witnesses who testified that they had never seen signs of abuse or heard Lorena complain about her marriage, but the defense countered with expert testimony explaining that domestic violence victims often hide their abuse from friends, family, and co-workers out of shame, fear, or hope that the situation will improve. The trial, which took place in January 1994 in Prince William County Circuit Court, became a cultural flashpoint, with feminist advocates arguing that Lorena was a victim who had been driven to desperate action by systemic failures to protect domestic violence survivors, while critics argued that her actions constituted vigilante justice that could not be excused regardless of what she had suffered. The jury heard several weeks of testimony, including graphic descriptions of the alleged abuse, medical testimony about the physical and psychological effects of domestic violence, and expert analysis of Lorena's mental state at the time of the incident. On January 21, 1994, after deliberating for several hours, the jury found Lorena Bobbitt not guilty by reason of temporary insanity, accepting the defense argument that she had experienced an irresistible impulse that rendered her unable to control her actions or appreciate their wrongfulness at the moment she severed her husband's penis. However, because the verdict was not guilty by reason of insanity rather than a simple acquittal, the judge ordered that Lorena undergo psychiatric evaluation to determine whether she posed a danger to herself or others and whether she required involuntary commitment to a mental health facility. Lorena was sent to Central State Hospital, a psychiatric institution in Petersburg, Virginia, where she was evaluated by mental health professionals who concluded that she was not dangerous and did not require long-term institutionalization. After 45 days of evaluation and treatment, Lorena was released from the psychiatric hospital and allowed to return to her life, though she faced ongoing media attention and public scrutiny. The Bobbitt case had profound cultural and legal impacts that extended far beyond the specific facts of the case. It brought national attention to the issue of domestic violence at a time when awareness of intimate partner abuse was still relatively limited in mainstream American culture, and it sparked important conversations about why victims of abuse sometimes remain with their abusers, why they often don't report violence to authorities, and what psychological effects prolonged abuse can have on victims' mental health and decision-making. The case also influenced how courts and juries thought about the irresistible impulse defense and temporary insanity claims in cases involving domestic violence, with many jurisdictions subsequently developing more nuanced approaches to evaluating such defenses that took into account the specific psychological dynamics of abuse situations. However, the case also generated backlash and concerns that it might encourage vigilante violence against abusers or provide a roadmap for people to escape accountability for violent crimes by claiming abuse and temporary insanity. John Wayne Bobbitt attempted to capitalize on his notoriety by appearing in pornographic films and paid media appearances, a career path that many observers found disturbing given the serious allegations of abuse and sexual violence against him. In 1994, John was tried on charges of marital sexual assault related to the rape allegations Lorena had made about the night of the incident, but he was acquitted, with the jury apparently unconvinced by the prosecution's evidence or perhaps influenced by the intense media circus surrounding both trials. John went on to have several subsequent arrests for domestic violence against other partners, lending credibility to Lorena's claims that he had a pattern of abusive behavior. Lorena, meanwhile, rebuilt her life after the trial, working as an advocate for domestic violence victims, establishing the Lorena's Red Wagon Foundation to help survivors of abuse, and eventually remarrying and having a daughter. In interviews decades after the incident, Lorena has expressed that she wishes the incident had never happened, but that she hopes her case has helped bring attention to the serious issue of domestic violence and encouraged other victims to seek help and escape abusive situations. The Bobbitt case remains one of the most famous examples of the irresistible impulse defense succeeding in a criminal trial, and it continues to be studied in law schools and cited in legal arguments involving domestic violence, temporary insanity, and the psychological effects of trauma on criminal responsibility. Number 4. The hypoglycemia defense. The blood sugar murder case. In November 1978, Dan White committed a shocking double murder that would become famous for the Twinkie defense, as discussed earlier in this compilation. But there have been other cases where defendants have successfully used metabolic and physiological defenses related to blood sugar levels and diabetes to avoid murder convictions, with one of the most remarkable being the case of Charles Biggs in Ohio. In 1988, Charles Biggs, a 46-year-old diabetic man from Cleveland, was charged with the brutal beating death of his wife, whom he allegedly attacked in their home during what prosecutors described as a domestic dispute. The evidence against Biggs appeared straightforward. He was found at the scene. His wife was dead from blunt force trauma consistent with being beaten, and there were no signs of forced entry or any other suspects. However, Biggs' defense team, after extensive medical evaluation, determined that he had been experiencing a severe hypoglycemic episode at the time of the killing, meaning his blood sugar had dropped to dangerously low levels that can cause altered mental states, confusion, aggression, and in extreme cases, unconscious or semi-conscious behavior that the person cannot control or remember. Hypoglycemia, particularly in diabetic patients who use insulin or certain medications to control their blood sugar, can occur when there is too much insulin in the bloodstream relative to the amount of glucose, causing blood sugar to drop below normal levels. Mild hypoglycemia causes symptoms like shakiness, sweating, and confusion, but severe hypoglycemia can produce symptoms remarkably similar to intoxication, including slurred speech, poor coordination, irrational behavior, and even violent outbursts or unconscious automatism. The defense presented medical testimony from endocrinologists and diabetes specialists who explained that Biggs had a history of poorly controlled diabetes, that he had been experiencing frequent episodes of hypoglycemia in the weeks before his wife's death, and that on the day of the incident, circumstances had aligned to create a perfect storm of factors that would have caused his blood sugar to plummet to extremely low levels. The defense established that Biggs had taken his usual insulin dose in the morning but had not eaten properly throughout the day due to a stomach illness, that he had engaged in physical activity that would have burned additional glucose, and that by evening his blood sugar had likely fallen to levels below 30 milligrams per deciliter, when normal fasting blood sugar is between 70 and 100 milligrams per deciliter. At such extremely low levels, the brain becomes deprived of glucose, which is its primary fuel source, and begins to malfunction in ways that can produce altered consciousness, aggressive behavior, and actions that the person cannot control or remember. Expert witnesses testified that severe hypoglycemia can essentially cause a form of temporary insanity or automatism, where the person's actions are not under their conscious control, and they have no memory of what occurred during the episode. The defense presented evidence that Biggs had no memory of the attack on his wife, that he was found in a confused and disoriented state when police arrived, that his blood sugar when tested at the hospital was dangerously low even hours after the incident, and that he had no history of violence toward his wife or anyone else, making it unlikely that he would have consciously chosen to kill her. The prosecution attempted to argue that Biggs could have been responsible for creating the conditions that led to his hypoglycemia, that he should have known better than to skip meals after taking insulin, and that his failure to properly manage his diabetes constituted recklessness that should not excuse him from criminal liability. However, the defense successfully argued that having diabetes and occasionally experiencing episodes of poor blood sugar control, even if due to negligence in self-care, should not strip someone of the right to an automatism defense when they commit actions during a severe hypoglycemic episode that they could not consciously control. The defense drew parallels to sleepwalking cases, arguing that just as a person who commits a crime while genuinely asleep cannot be held criminally responsible because they lacked conscious control, a person in a severe hypoglycemic state that has rendered them unconscious or semi-conscious should similarly not be held responsible for actions they could not control or remember. Medical experts testified about documented cases of people experiencing hypoglycemic episodes who had engaged in bizarre, out-of-character, and sometimes violent behaviors that they had no memory of afterward, including cases of diabetic patients who had assaulted family members, destroyed property, or engaged in other dangerous actions while their blood sugar was critically low. The jury was presented with extensive medical evidence, including brain imaging studies showing how glucose deprivation affects brain function, case studies of hypoglycemic episodes from medical literature, and testimony from Biggs' treating physicians about his diabetes history and the likelihood that he had been in a severe hypoglycemic state at the time of his wife's death. The prosecution called their own medical experts who testified that while hypoglycemia can cause altered mental states, it would be extremely unusual for someone to engage in sustained, purposeful violence during a hypoglycemic episode, and that most people experiencing severe low blood sugar would become weak, lethargic, and eventually unconscious rather than aggressive and violent. However, the defense countered with evidence that individual responses to hypoglycemia vary widely, that some people do experience a phenomenon called hypoglycemic rage where they become combative and aggressive, and that Biggs had documented instances in his medical history where he had become irritable and confused during previous hypoglycemic episodes. The trial resulted in a verdict of not guilty by reason of insanity, with the jury accepting the defense's argument that Biggs had been in an altered mental state caused by severe hypoglycemia that rendered him unable to appreciate the wrongfulness of his actions or to control his behavior. Similar to other cases involving automatism defenses, Biggs was not simply released but was instead committed to a mental health facility for evaluation, though in his case the evaluation concluded that he did not suffer from any ongoing mental illness and that with proper diabetes management and education, he was not a danger to others, leading to his release after a period of supervision. The hypoglycemia defense has been attempted in numerous criminal cases with varying degrees of success, and courts have generally approached such defenses with skepticism, requiring extensive medical evidence and expert testimony to establish that the defendant was genuinely in a state of automatism rather than simply claiming a convenient excuse for criminal behavior. In a 1992 case in Florida, a diabetic man successfully used the hypoglycemia defense after being charged with assault, when he attacked a police officer during what medical evidence showed was a severe hypoglycemic episode, with the court finding that he had been in a state similar to sleepwalking and could not be held criminally responsible. However, in other cases, courts have rejected hypoglycemia defenses when the evidence suggested that the defendant had deliberately failed to manage their diabetes in order to create a defense, when the violent behavior was too complex and sustained to be plausibly explained by low blood sugar alone, or when expert testimony established that the defendant's blood sugar, while low, was not low enough to cause the kind of automatism or altered consciousness that would negate criminal responsibility. The success of hypoglycemia and other metabolic defenses has raised important questions about the intersection of medical conditions and criminal law, particularly regarding how the justice system should treat defendants whose criminal actions may have been influenced or caused by physiological conditions beyond their conscious control. Some legal scholars and medical ethicists have argued that as our understanding of how brain chemistry, blood sugar, hormones, and other physiological factors affect behavior continues to advance, the criminal justice system will need to develop more sophisticated approaches to assessing criminal responsibility that take these factors into account, while still maintaining meaningful standards of accountability. The hypoglycemia defense also highlights the importance of proper medical management for people with chronic conditions like diabetes, as failure to maintain proper blood sugar control can have serious consequences not only for the individual's health but potentially for public safety if severe episodes lead to dangerous behaviors. Medical and legal experts generally agree that while physiological conditions like hypoglycemia can potentially provide valid defenses to criminal charges in rare cases where they genuinely cause automatism or altered consciousness, defendants bear a heavy burden of proof to demonstrate that their condition actually caused the criminal behavior and that they were not simply using a medical diagnosis as a convenient excuse for actions they consciously chose to commit. Number 3. The XYY chromosome defense, the genetic predisposition argument in the late 1960s and early 1970s. Defense attorneys in several high-profile criminal cases attempted to use a controversial genetic defense based on the presence of an extra Y chromosome in male defendants, arguing that this chromosomal abnormality predisposed them to violent and aggressive behavior and should therefore mitigate their criminal responsibility. The XYY chromosome defense was based on flawed and now discredited research suggesting that men born with an extra Y chromosome, a condition affecting approximately 1 in 1,000 males, were more likely to be tall, have lower intelligence, and exhibit increased aggression and criminal tendencies compared to men with the typical XY chromosome pattern. The most famous case involving this defense was that of Richard Speck, who murdered 8 student nurses in Chicago in 1966 in one of the most horrific mass murders in American history, though the XYY defense was not actually used at his trial despite early speculation that it might be, with Speck's defense team ultimately deciding against pursuing this strategy after genetic testing showed he did not have the XYY genotype. However, the defense was successfully employed in several other cases during this period, most notably in the 1968 case of Daniel Hugon in France and the 1969 case of Sean Farley in New York. Daniel Hugon was a French citizen charged with murder who became one of the first defendants to successfully use the XYY chromosome defense when his attorneys presented genetic evidence showing that he possessed an extra Y chromosome and argued that this genetic abnormality had contributed to his violent behavior by making him constitutionally predisposed to aggression and impulsivity. The defense relied on scientific papers published in the mid-1960s that claimed to have found a higher prevalence of XYY genotypes among incarcerated violent criminals and men in psychiatric institutions compared to the general population, suggesting a possible link between the chromosomal abnormality and antisocial behavior. Hugon's defense team brought in geneticists and psychiatrists who testified that the extra Y chromosome could affect brain development and hormone levels in ways that might increase aggression, reduce impulse control, and make violent outbursts more likely. The French court, influenced by this testimony and perhaps by the novelty of genetic evidence in criminal proceedings, found that Hugon's XYY genotype was a mitigating factor that reduced his culpability for the murder, resulting in a reduced sentence compared to what he would have received without this genetic evidence. The Hugon case sparked intense interest among defense attorneys internationally, and soon the XYY defense was being attempted in courtrooms across Europe and the United States. In Australia in 1969, Lawrence Honnell was charged with murdering an elderly widow during a robbery, and his defense team successfully argued that his XYY chromosome pattern had contributed to his violent behavior, resulting in a verdict of not guilty by reason of insanity and commitment to a psychiatric facility rather than imprisonment. The most significant American case involving the XYY defense was that of Sean Farley, a New York man charged with murder in 1969 whose defense attorney, Irvin Edelman, presented extensive genetic and psychiatric evidence arguing that Farley's XYY genotype had predisposed him to the violent behavior that led to the killing. The defense brought in prominent geneticists who testified about the alleged connection between XYY chromosomes and criminal behavior, citing studies that claimed to show elevated rates of XYY genotypes in prison populations and suggesting that the extra Y chromosome might lead to increased testosterone production, altered brain chemistry, or other physiological changes that could make violence more likely. The prosecution vigorously challenged this defense, bringing in their own genetic experts who testified that the research linking XYY chromosomes to criminal behavior was methodologically flawed, based on small sample sizes, and failed to account for confounding variables. Critics of the XYY research pointed out that many studies finding elevated rates of XYY genotypes in criminal populations had been conducted in institutions housing individuals with developmental disabilities or mental illness, meaning the population studied were not representative of XYY individuals generally, and that selection bias in these studies made any conclusions about XYY and criminality highly suspect. Additionally, The vast majority of men with XYY chromosomes never commit any crimes and live completely normal lives, making it scientifically unjustifiable to claim that the condition causes criminal behavior. Despite these scientific criticisms, Farley's jury was apparently persuaded by the genetic defense, and while they did not acquit him entirely, they found him guilty of a reduced charge of manslaughter rather than murder, accepting the argument that his chromosomal abnormality had diminished his capacity to control his behavior. The success of the XYY defense in these cases alarmed many legal scholars, scientists, and civil rights advocates who worried that genetic determinism was being used to excuse criminal behavior in ways that could undermine personal responsibility and potentially stigmatize all individuals with XYY chromosomes as inherently dangerous. As more rigorous genetic research was conducted in the 1970s and 1980s, the scientific consensus shifted decisively against the claims that had supported the XYY defense. Large-scale population studies found that while men with XYY chromosomes might be slightly more likely to have learning difficulties and might be marginally overrepresented in certain criminal justice populations, there was no credible evidence that the condition caused or significantly predisposed individuals to violent behavior. Researchers discovered that the apparent overrepresentation of XYY individuals in prisons could be explained by factors such as lower average IQ, which might make crime detection more likely, and taller height, which might make individuals more noticeable to law enforcement, rather than any inherent tendency toward violence. The American Medical Association, the American Bar Association, and major genetics organizations all issued statements in the 1970s warning against the use of XYY genotype evidence in criminal proceedings, arguing that the science did not support the claims being made and that allowing such evidence risked legitimizing genetic determinism in ways that were both scientifically unfounded and potentially discriminatory. By the late 1970s and early 1980s, courts in most jurisdictions had become much more skeptical of XYY defenses, with judges increasingly ruling that evidence of a defendant's chromosomal makeup was inadmissible unless the defense could demonstrate clear scientific support for a causal connection between the genetic condition and the criminal behavior, a standard that the XYY defense could not meet given the state of the scientific evidence. In a landmark 1975 decision, the Maryland Court of Appeals ruled in the case of Millard v. State that XYY chromosome evidence should not be admitted in criminal trials because the scientific research did not establish a reliable connection between the chromosomal abnormality and criminal behavior, and because allowing such evidence would be more prejudicial than probative. Other appellate courts followed suit, and by the 1980s the XYY defense had largely disappeared from American and European courtrooms, remembered primarily as an example of how unreliable or preliminary scientific evidence can be misused in legal proceedings before the scientific community has reached consensus. The rise and fall of the XYY defense provides important lessons about the relationship between science and law, particularly regarding how courts should evaluate novel scientific evidence and expert testimony. The case for more rigorous standards in admitting scientific evidence in criminal trials was strengthened by the XYY cases, ultimately contributing to the development of more stringent admissibility standards such as those established in the Supreme Court's Daubert decision in 1993, which required that scientific evidence be based on methodology that has been tested, subjected to peer review, has known error rates, and is generally accepted in the relevant scientific community. The XYY cases also raised enduring questions about genetic determinism and free will that remain relevant today as genetic research continues to advance and identify genes associated with various behavioral traits and psychiatric conditions. Modern neuroscience and behavioral genetics have indeed found that genetic factors play a role in influencing personality traits, impulse control, and susceptibility to certain psychiatric conditions that might increase the likelihood of criminal behavior. But the scientific consensus is that genes interact with environment in complex ways and that genetic predispositions do not determine behavior in the simple, direct manner that the XYY defense claimed. Contemporary legal and ethical discussions about genetic evidence in criminal law tend to focus on whether genetic information should be considered as mitigating evidence during sentencing rather than as a defense to guilt, acknowledging that while genes may influence behavior, they do not remove moral agency or eliminate criminal responsibility in the way that true automatism or severe mental illness might. The story of the XYY defense serves as a reminder of the importance of maintaining high standards for scientific evidence in courtrooms, of being skeptical about sensational claims based on preliminary research, and of carefully considering the broader social implications of allowing genetic or biological arguments to be used as defenses to criminal behavior. Number 2. The Black Rage defense. Colin Ferguson's rejected but influential argument. On December 7, 1993, Colin Ferguson, a Jamaican-born man who had immigrated to the United States and become increasingly bitter about perceived racism and discrimination he experienced, boarded the 5:33 p.m. Long Island Railroad commuter train from New York City to Hicksville and, shortly after the train departed, pulled out a Ruger 9mm pistol and systematically began shooting passengers in a rampage that lasted several minutes and resulted in 6 deaths and 19 injuries before passengers tackled and subdued him. The attack was one of the deadliest mass shootings on public transportation in American history, and the evidence against Ferguson was absolutely overwhelming. Dozens of witnesses saw him commit the shootings, he was captured at the scene with the murder weapon, and police found handwritten notes in his possession detailing his hatred of white people, Asians, and what he called Uncle Tom blacks. The notes expressed Ferguson's belief that he was being persecuted by a racist society and included a list of people and groups he blamed for his problems. Given this evidence, a conviction seemed certain, and the only real legal question was whether Ferguson would face the death penalty or life imprisonment. However, Ferguson's initial defense attorneys, William Kunstler and Ronald Kuby, 2 well-known civil rights lawyers, proposed a groundbreaking and highly controversial defense strategy that they termed the Black Rage defense, arguing that Ferguson had been driven to temporary insanity by the cumulative psychological effects of experiencing racism throughout his life as a black man in America. The defense theory was based on the premise that constant exposure to racial discrimination, microaggressions, institutional racism, and the psychological trauma of living in a society structured by white supremacy had created a mental condition in Ferguson that impaired his ability to control his actions or appreciate their wrongfulness. Kunstler and Kuby planned to present expert testimony from psychiatrists and psychologists who would explain that black Americans, particularly black men, experience unique forms of psychological stress and trauma related to racism that can, in extreme cases, lead to violent outbursts against perceived oppressors. The defense was influenced by the 1968 book Black Rage by psychiatrists William Greer and Price Cobbs, which discussed the psychological impacts of racism on African Americans and argued that the anger and rage that black people feel in response to oppression is a rational response to an irrational and unjust system. Kunstler and Kuby argued that Ferguson's experience of racism in employment, housing, education, and daily interactions had created a psychological condition where he genuinely believed he was under attack by a racist society, and that his violent response, while tragic and wrong, was the result of a mental state created by the racism he had experienced rather than the product of free will or criminal intent. The proposed defense immediately sparked intense controversy, with critics arguing that it was offensive, dangerous, and potentially racist itself to suggest that black people who experience racism might be prone to uncontrollable violent rage. Many African American leaders, intellectuals, and civil rights advocates denounced the Black Rage defense, arguing that it played into harmful stereotypes about black violence, that it suggested black people lacked self-control or moral agency, and that it could be used to justify discrimination by portraying black people as potentially dangerous or mentally unstable. The prosecution and victims' families were outraged by the proposed defense, arguing that it was a cynical attempt to excuse mass murder by exploiting sympathy for victims of racism, and that it would set a terrible precedent if defendants could avoid responsibility for horrific crimes by claiming that experiencing discrimination had driven them to violence. As the case proceeded toward trial, Colin Ferguson made the stunning decision to fire Kunstler and Kuby and represent himself, rejecting the Black Rage defense entirely and instead claiming that he had been framed and that he was not the shooter despite overwhelming evidence to the contrary. Ferguson's decision to serve as his own attorney meant that the Black Rage defense was never actually presented to a jury in his case. But the extensive media coverage of the proposed defense strategy and the public debates it sparked had lasting impacts on legal discourse about race, mental health, and criminal responsibility. During Ferguson's trial in 1995, which became a bizarre spectacle due to his insistence on representing himself and his delusional claims of innocence, he was convicted on all counts of murder and attempted murder and was sentenced to 315 years and 8 months in prison, effectively a life sentence with no possibility of parole. While the Black Rage defense was not used in Ferguson's case, similar defenses arguing that the psychological effects of racism should be considered as mitigating factors in criminal cases have been attempted in other cases with limited success. In a 1994 case in New York, Stephen Robinson was acquitted of murder charges after his attorneys successfully argued that he had suffered a psychological breakdown related to racial harassment and discrimination, though the defense was framed as temporary insanity resulting from extreme stress rather than specifically as black rage. In a 1995 case in Texas, Felicia Morgan's attorneys attempted to use an urban survival syndrome defense that incorporated elements of the black rage argument, claiming that growing up as a black woman in a violent, impoverished neighborhood where racism limited opportunities and created constant stress had affected her mental state, though this defense was ultimately rejected by the court. Legal scholars and psychologists have engaged in extensive debates about whether and how the psychological impacts of racism should be considered in criminal cases. Proponents of considering racism-related trauma as a mitigating factor argue that the criminal justice system already considers various forms of environmental stress and trauma, such as child abuse, combat exposure, or other adverse experiences, and that there is no principled reason to exclude the well-documented psychological effects of experiencing racism from similar consideration. They point to extensive research showing that racial discrimination is associated with increased rates of depression, anxiety, PTSD, and other mental health conditions, and that chronic exposure to racism creates measurable physiological stress responses that can affect brain function and behavior. However, critics argue that while the psychological effects of racism are real and should be taken seriously, allowing them to serve as a defense to violent crime would be both logically problematic and socially dangerous, potentially perpetuating rather than challenging racism by suggesting that people who experience discrimination cannot be held to normal standards of self-control and moral responsibility. The debate also touches on complex questions about group identity, individual variation, and the relationship between social conditions and personal agency, with some scholars arguing that while racism undoubtedly affects individuals psychologically, the specific effects vary greatly from person to person and cannot be presumed based on group membership or generalized experiences. The legacy of the black rage defense debate has been to spark more nuanced conversations about how courts should consider evidence of trauma, discrimination, and adverse social conditions when evaluating criminal responsibility and determining appropriate sentences. Modern approaches tend to focus on presenting evidence of racism-related trauma as one factor among many that might help explain a defendant's mental state or serve as a mitigating factor during sentencing, rather than as a complete defense to criminal liability. The debate has also contributed to broader discussions about how the criminal justice system itself perpetuates racial inequalities through disparate sentencing, discriminatory enforcement, and inadequate consideration of the social contexts in which crimes occur, leading some advocates to argue that true justice requires not just individual defenses based on experiencing racism but systematic reforms to address how racism shapes the entire criminal justice process. Colin Ferguson remains in prison and has repeatedly been denied parole, with the parole board citing the severity of his crimes and his apparent lack of remorse or insight into his actions. And while the black rage defense was never actually tested in his case, the controversy it generated continues to influence how lawyers, judges, and juries think about the intersections of race, trauma, mental health, and criminal responsibility. Number 1. The victim consent defense. Armin Meiwes and the cannibal of Rotenburg. In March 2001, Armin Meiwes, a 42-year-old computer technician living in the small German town of Rotenburg, killed, dismembered, and consumed portions of Bernd Jürgen Armando Brandes, a 43-year-old engineer from Berlin, in what would become one of the most disturbing and legally complex criminal cases in modern European history. The case challenged fundamental assumptions about criminal law, the limits of consent, personal autonomy, and the role of the state in preventing individuals from harming themselves, while also raising profound questions about morality, mental illness, and the nature of evil. What made this case particularly unusual from a legal standpoint was that Meiwes did not kidnap, coerce, or force Brandes to participate in the acts that led to his death, but rather Brandes had actively sought out someone who would kill and eat him, had responded to an internet advertisement Meiwes had posted seeking someone willing to be slaughtered and consumed, and had traveled voluntarily to Mew's isolated farmhouse specifically for the purpose of being killed and cannibalized. The two men had exchanged numerous emails and messages discussing in explicit detail what would happen, with Brandes expressing his desire to be eaten and Meiwes confirming his willingness to fulfill this desire. On the evening of March 9, 2001, Brandes arrived at Mew's home, and over the course of several hours, the two men engaged in various activities that Brandes had requested, including Meiwes severing Brandes' penis, which both men then attempted to consume together before Brandes, suffering from severe blood loss and pain, took sleeping pills and alcohol. Meiwes then stabbed Brandes in the throat, killed him, dismembered his body, and over the following months, stored portions of the flesh in his freezer and periodically cooked and ate approximately 40 pounds of human flesh. The entire incident was videotaped at Brandis' request, creating a disturbing record that would later serve as crucial evidence at trial. Meiwes was not discovered until December 2002, when he posted another internet advertisement seeking additional willing victims, which caught the attention of law enforcement, leading to his arrest and the discovery of Brandis' remains. When charged with murder, Meiwes and his defense team, led by attorney Harold Ermel, argued that he should not be convicted of murder because Brandis had given full, informed, and voluntary consent to everything that occurred, that Brandis had desired and sought out his own death, and that Meiwes had merely facilitated another person's autonomous choice about what to do with his own body. The defense presented extensive evidence of the email correspondence between Meiwes and Brandis, showing that Brandis had initiated contact, had clearly and repeatedly expressed his desire to be killed and eaten, had traveled to Mewes' home voluntarily and with full knowledge of what would happen, and had actively participated in the early stages of the killing, including consuming his own severed flesh. The defense showed the videotape, which despite its horrific content, appeared to demonstrate that Brandis was a willing and even enthusiastic participant in the events, that he was not forced or coerced, and that he had every opportunity to leave but chose to stay and proceed with the plan. Mewes' attorneys argued that under these circumstances, the appropriate charge should be assisted suicide or euthanasia rather than murder, as German law at the time did not explicitly criminalize assisting someone in ending their own life if that person had clearly expressed a desire to die and had given voluntary consent. The prosecution, led by Marcus Kohler, argued that regardless of Brandis' consent, killing another human being was murder under German law, that consent is not a valid defense to homicide except in very limited circumstances such as euthanasia for terminally ill patients, and that the state has a fundamental interest in protecting human life that overrides individual autonomy when it comes to killing. The prosecution contended that allowing someone to consent to being killed and eaten would undermine basic legal and ethical principles about the sanctity of human life, would create a dangerous precedent that could be exploited by murderers who might claim their victims consented, and would fail to protect vulnerable individuals who might make irrational or coerced decisions to end their lives. The prosecution also presented psychiatric evidence that both Meiwes and Brandis suffered from severe psychological disorders that impaired their judgment and ability to make rational decisions, with Brandis having a documented history of suicidal ideation and self-harm fantasies, and Meiwes having developed an extreme sexual paraphilia involving fantasies of cannibalism that had consumed his life. Psychiatrists testified that Brandis' desire to be killed and eaten was not a rational expression of autonomy, but rather a manifestation of severe mental illness, and that he should have been provided with psychiatric treatment rather than having his self-destructive fantasies enabled. Similarly, experts testified that Meiwes suffered from a rare and extreme form of paraphilia that had led him to spend years seeking someone to consume, and that his actions, while technically consensual, were driven by compulsions and fantasies that reflected serious psychological disturbance rather than healthy sexuality or normal human behavior. The trial, which began in December 2003 in Kassel, Germany, became an international media sensation, with extensive coverage of the legal and ethical questions raised by the case. The court heard testimony about the nature of consent, the limits of personal autonomy, the role of mental illness in decision-making capacity, and the appropriate scope of criminal law in regulating private behavior between consenting adults. Defense attorneys drew analogies to other contexts where German law respects individual autonomy even when choices might be harmful, such as the right to refuse medical treatment, the right to engage in dangerous sports or activities, and the relatively permissive legal treatment of assisted suicide for people with terminal illnesses. However, the prosecution successfully argued that there is a fundamental difference between passive choices to refuse treatment or to engage in risky activities and actively killing another person, and that society's interest in preventing homicide is so strong that it must override individual autonomy even when the victim consents. In February 2004, the court delivered a verdict that attempted to navigate the unprecedented legal and moral complexities of the case. Meiwes was convicted not of murder but of manslaughter, with the court finding that while he had killed Brandis, the fact that Brandis had given explicit consent and had desired his own death meant that Meiwes lacked the malicious intent required for a murder conviction under German law. The court sentenced Meiwes to 8.5 years in prison, a relatively lenient sentence that reflected the unusual circumstances of voluntary victim participation. However, this verdict and sentence sparked immediate outrage from prosecutors, victims' rights advocates, and members of the public who felt that the sentence was far too lenient for such a horrific crime and that the court had given too much weight to the consent defense. The prosecution appealed the verdict, arguing that the trial court had erred in finding that victim consent could reduce murder to manslaughter and that Meiwes' actions clearly constituted murder regardless of Brandis' wishes. The German Federal Court of Justice agreed to hear the appeal and in April 2005 ordered a retrial, finding that the lower court had not properly considered whether Meiwes could be convicted of murder based on sexual sadism, which under German law can constitute the base motives necessary for a murder conviction even when the victim consents to being killed. At the retrial in 2006, the prosecution presented additional psychiatric evidence arguing that Meiwes had killed Brandis at least in part to satisfy his own sexual and psychological compulsions, that he had derived sadistic pleasure from the killing and consumption of human flesh, and that these base motives meant his crime should be classified as murder regardless of Brandis' consent. The defense argued that Meiwes' motivation was not sadistic pleasure but rather a desire to fulfill what he saw as a kind of ultimate intimacy and union with another person through consumption, a bizarre but sincere belief that he was honoring Brandis' wishes and creating a permanent bond. The second trial resulted in a conviction for murder, with the court finding that Meiwes had acted on base motives including sexual sadism, and he was sentenced to life imprisonment. The verdict was upheld on appeal, and Meiwes remains in prison, where he has reportedly become a vegetarian and has expressed remorse for his actions, though he continues to maintain that Brandis genuinely wanted to die and that he was simply fulfilling another person's deepest desire. The Meiwes case has had significant impacts on German law and international discussions about the limits of consent in criminal law. In the wake of the case, Germany amended its criminal code to explicitly criminalize certain forms of consensual harm, making it clear that consent is not a defense when someone agrees to be killed, regardless of their mental state or desires. The case has been extensively analyzed by legal scholars, philosophers, and ethicists who have debated whether the state should prohibit consensual acts between adults even when those acts result in death, with some arguing that true respect for individual autonomy requires allowing people to make even fatal choices about their own bodies, while others contend that there are certain harms that are so severe that society must prohibit them regardless of consent in order to protect human dignity and prevent exploitation of vulnerable individuals. The case also raised important questions about mental illness and capacity to consent, as many observers argued that Brandis' desire to be killed and eaten was so clearly a product of severe mental illness that his consent should not have been considered legally valid, analogous to how the law does not recognize consent from people with severe cognitive impairments or who are under duress. The Meiwes case remains one of the most philosophically and legally challenging criminal cases of the modern era, forcing courts and societies to grapple with fundamental questions about autonomy, consent, the value of human life, the role of the state in preventing self-harm, and where society should draw lines between protected private behavior and conduct that must be criminalized regardless of whether the participants consented.